During trial, do I need permission from the judge in order to make an objection to what my opponent is asking? You want to know the answer? Come join me for a moment as I share with you some terrific information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law here in the state of New York. The answer is no. I don't need anybody's permission to jump up out of my chair at trial and yell out, "Objection, Judge, that's irrelevant. Objection, Judge, hearsay. Objection, Judge, he's leading the witness. Objection, Judge, he's badgering my witness." There are many different types of objections that an attorney can make. And the reality is that I don't need anybody's permission to make that objection. Why is that? It's because I have an obligation to my client to represent his or her best interests. And now, if during questioning by the defense, now the defense attorney is asking questions and I feel that the question is inappropriate, I have an obligation to stand up and assert my client's rights. Now, how do I do that? I do that by standing up, respecting the court, and saying, "Objection!" And now, briefly, I have to tell the judge what my objection is. What's the problem with the question? The judge will listen to my question, listen to the reason why I'm objecting, and then make an immediate decision about whether or not I am correct or incorrect. If the judge feels that the question is not appropriate, the judge will say objection sustained, which means that the defense attorney cannot ask the question. Now, if he's already asked the question, it means that the witness is not to answer it. What happens, though, if he says, "No, objection overruled"? It means he doesn't think I'm right. And he's basically telling the defense attorney, "Go ahead, continue with your question, let's hear the answer." An attorney has an obligation, regardless of which side, plaintiff or defendant, where if he feels that something is being done improperly or prejudicing his client in some way, he must stand up, make an objection, tell the judge in a coherent fashion what the objection is, and then wait for the judge to rule on whether or not he agrees or disagrees with that objection. So we don't need permission from the judge, we don't need permission from my adversary or from a witness to go ahead and make that objection. We have to interrupt the proceedings, and although it's inconvenient, and if the attorney continues to make objections over and over and over again, it might be perceived by the judge and the jury as a stalling tactic, as something that they're trying to hide. So that's why you have to be careful in how many times you're going to object, and you really have to pick and choose which battles you're going to go after. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what goes on in a trial involving an accident case or a medical malpractice case or even a wrongful death case here in the state of New York. You know, I recognize that you're watching this video because you probably have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but you have questions that need to be answered first, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.